Right.
and basically remain along.
Right, that's good, that's good. And so, notice, that's very important because you have to know the distinction between those two types of advices to be an effective and competent lawyer. You don't want to turn away your client if you can certainly advise them. But in my hypo, since the law is ambiguous, and this person is coming to you to get advice, not how to set up a criminal enterprise, then that's perfectly fine. You're not assisting a client in engaging in fraudulent conduct. And so you have to really look at these rules as well to understand how to apply it. Also, you're going to see later on that the scope of representation is going to impact the type of advice that you're giving. So in that hypo, you're just focusing on that discrete issue of someone wanting to create or invent a business transaction. Then the question is, can you do this? And that's what lawyers do. We talk about permissible conduct all the time after we analyze something. So that's good. So let's look at like the readings on page 67 sort of make the point that I was making about being able to distinguish between fraud and legal advice. Well, look in the middle of page 67. This is a good rule of thumb. It says, a good rule of thumb is that a lawyer should be wary if a client's past or contemplated conduct appears to involve an intentional, annoying misrepresentation to another person. So on my hypo, that was just a preliminary discussion about things. There was no course of conduct that would give the lawyer pause. But that's something else that a lawyer has to look at. And so fraud is this purposeful deception. Not really defined in the rule, but we know that that is what fraud is. Look on page 68. Now this is a tough case. We have this is on page 68, the dying mother. So someone, I've given the facts the last couple of cases. Someone go through the facts and sort of analyze them like you're the lawyer in this case, and then sort of take me through what you might have to do. So there are financial consequences to not doing this. Yes, go ahead.
Okay, so in this case, the attorney has been approached to do estate planning for a dying mother. Her only asset is a house worth about $250,000, which she wants to go equally to her 4 kids. Her current will have to be probated, which would incur attorney's fees in the amount of $10,000. And because of the situation, she doesn't want the children to have to pay those attorney's fees. We come up with an estate plan that would have her put the house in a trust where she would remain in control of it while she was alive, and after that, the children would be, as the beneficiaries of the trust, would each get their share of the house after it was sold. So, you present this estate plan to the mother, and she does not assent to it. She says, I want to think about it. She goes away, and then later you're contacted by the children after mom is in the hospital dying of cancer and in and out of consciousness. The children ask you to bring the documents to the hospital. At the hospital, you cannot, I think we're supposed to look for lucid moments, and when you have a lucid moment, you can get consent to sign documents. But in this case, you're not seeing that, and the doctors don't think mom is going to remain conscious or survive very much longer. And the children ask for you to let one of them sign the documents in mom's name, and have your office people sign as witnesses later, not after seeing them sign it, but back at the office. you explain the consequences of having the children they don't have a power of attorney, so they really can't sign for mom, and it has to be witnessed and notarized in order to be effective.
Okay. Yeah. So a number of problems. The forgery or fraud by signing her name, then the attestation back in the office, not only by the lawyer, but by lawyer's assistants. But then you have this question of who is the client as well. Is the dying mother the client, or is the client just Nancy? How would you resolve this? Ms. Wack.
So the dying mother is the client. You cannot allow a child of a parent to dictate their estate plan. And so unless mom does have what you could consider a lucid moment and sign the documents, there's no way I would do it.
Mhm.
So it's a $250,000 house. The probate is $10,000. So they're still going to get. I feel really bad for them. I would say, look, this is not legal, and it's a drop in the bucket compared to what would happen if you engaged in fraud.
Okay. Okay, so what if I feel really sorry. I think everything you said is right and probably the way to resolve the problem. But what if I said I feel really sorry for these people? No one is ever going to know. All of the children are on the same page. They don't want to pay this $10,000 that they really don't have. What you said about the difference between the house and the probate is certainly important, but they can only see this $10,000. Please, we want you to do this. Maybe our client isn't really Gloria. Our client is Nancy, and not the children. No one will know, and it just we sign this and everything will be fine. What about that?
No, I wouldn't change it.
Mr. Lynn, is that right? No?
It's more Denores last time.
Huh?
Denores on me still.
I'm sorry?
Denores.
Okay, go ahead. Mr. No, everybody is like, oh, we're gonna have to do this again. Mr. Denores, go ahead. Go ahead.
I mean, I wouldn't do it, but I might offer like a different plan, basically just use the $10,000, and then like whenever I can like do the probate for them, and when I sell the house, I'll take $10,000 off of it.
Huh.
So like they still get everything they want.
Well, who signs all the papers and all that? Somebody else? Not you. Okay. But that could be kind of tricky too. That's why I'm not being flipped. You want to do something else, but what about getting this? You're saving them the $10,000. I get it. Yeah. Ms. Moore, go ahead.
I think it's risky because you have a group of people that are in this together who are siblings who may not get along and may not agree with how the money is ended that way.
They're getting along now, though. Yeah. Yeah.
And so if one of them gets upset by the way things were handled,
Yeah.
they could go to the bus and that would be a problem.
Yeah. So whenever money is involved, things get funny. You'll see that's what happened in the real case. But yeah, go ahead.
I feel like even if the kids are in agreement, then like you're still gonna have to bring the witnesses on board and ask them to do something fraudulent, and the notary if it's not the attorney, if it's someone else. So that's like more people that like you don't know if they're gonna be okay with that yet.
That's right. So notice you pointed out to how this thing expands. That's good. So there are like 2 or 3 rules that are working here. Could we do what they wanted and requested? All of you point out very vigorously, no, and that is right. And there is a discussion about whether or not you should do this, and we said the answer is no. But we could look at a number of different things. One is we would be assisting a client to engage in fraudulent conduct. I mean, that's clear from the facts. Everyone knows that this is not Gloria's signature, it's someone else's. And even though the siblings are in accord now, things get funny when money is involved, and that's exactly what happened. One of the siblings moved into the house, decided he wanted to keep it. I don't like this, and then it unraveled from there. What do you think happened to the attorney? The attorney felt sorry for him, and he did it. He did it. So what do you? What do you think happened to him? And he made this argument. Gloria, the mother, is really my client, so I'm not really committing fraud. I never counseled or assisted her to commit fraud, so there's no fraud here. And you know what happened to that argument. It's a strong argument. So and he was admitted in 2 places, Maryland and Virginia. Get 2 different results. What do you think happened to him? Yeah. Go ahead. Ms. Washington.
So I think that probably he got suspended for a certain number of time, and he had to take some ethics classes.
Yeah. But he was disbarred in Maryland. And he was suspended for 2.5 years in Virginia. 2 years, 6 months in Virginia. And so I think he's practicing in Virginia now, but he was disbarred in Maryland. Now, you have to look at other implications as well. We have, if you're talking about this type of fraud, this could go to non-lawyer assistants as well. So when they go back to the office and affirm that this was signed in their presence, you are directing non-lawyer assistants to engage in misconduct. And so you cannot evade the scope and impact of these rules by saying, oh, somebody else who's a non-lawyer did it. So 5.3 talks about responsibilities regarding non-lawyer assistants. So you're responsible for everyone in your office, large firm or small firm, whatever. They're acting under your direction. And this is helping us get into supervisory attorneys and that type of thing. So 5.3 says, a lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. So if you have this agent working for you, you have to make sure that, I'll just put direct supervisory authority. That means compliance by non-lawyer assistant. And so we would be responsible for the conduct of that person as well, because C tells us this: we're responsible for the conduct of such a person if, I'll just put responsible for violation of So this problem is good because it shows multiple layers of liability. So the lawyer would have ordered with knowledge of the specific conduct and ratify that conduct by saying that they had affirmed this will. And so notice that if this lawyer is suspended, the lawyer has to do a number of things. So even though he was disbarred in Maryland, he still probably had clients in Virginia. And when that lawyer is suspended, he has to notify his clients and opposing counsel and any judges in any litigations and transactions, and has to assist those clients that he will not be representing during the suspension to make alternate arrangements in accordance with the client's wishes. So notice that. So a lawyer certainly can, if you look on page 73, certainly can be disciplined for the actions of an employee. So that was the non-lawyer scenario. We also have a scenario, and this is on page 73. You also have a scenario where 5.1, and you don't have to remember these rule numbers, I'm just saying them for easy reference. So under 5.1, you have sort of a hierarchy of supervisory authority. But keep in mind, that is not going to absolve you from your responsibilities. All of you are going to be sort of starting out. You'll be, I hate the term, subordinate lawyers under the direct supervision. But that's fine. But that doesn't insulate you from liability. Because you'll see how 5.1 works. So this is responsibilities of partners, managers, so notice how the rule fits any type of scenario you'll be in. Big firm, small firm, public interest organization, even think tank, you have this hierarchy. And so on page 73, it points to 5.1C2. And that just makes the similar point that I made with non-lawyers. A lawyer is responsible for another lawyer's violation of the professional rules if the lawyer has some type of managerial authority and knows of the conduct at a time when it could have been remedied or mitigated. So on page 73, we're talking about that supervisory authority and how that opens up the supervisory lawyer to liability if that lawyer knows and has responsibility for that other lawyer who's working for them under direct supervisory authority. Now you see two terms under C2. Comparable managerial authority and you see direct supervisory authority. So this language is designed to cover all situations where you have a attorney who's higher up in the hierarchy, the way that the organization is structured, who is responsible for supervising in some way. So comparable managerial authority in a large major firm could be the managing law partner who deals with this department, and then there are people under him. The senior associate who's working with the junior associate on a problem. So there are levels of decision-making responsibility, but under any level, there is no insulation from liability. Because you see the full rule, 5.1C2 says, a lawyer shall be responsible for another lawyer's violation of the rules of professional responsibility if, then number 2, that lawyer has comparable managerial authority or has direct supervisory authority and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to make remedial reasonable remedial action. So if you know about it and you're the supervisor, you have to correct it as soon as it comes to your attention. And so that also means that, we'll see later, as a subordinate attorney, you can't say, well, that's what he told me to do, that's my supervisor, so I just signed off on it too. You'll see that you are open to liability as well under 5.2. And this is just a lawyer who is taking orders from someone else. So you're bound by those rules of professional conduct, notwithstanding that the lawyer acted at the direction of another person. Now there is some play in the rules. Say that there is, the conduct isn't illegal or anything, but you disagree with what the supervisor is telling you. You go back and forth, and then the supervisor finally says, well, I'm the boss, I'm making this call. It's not anything illegal or anything. You just may disagree with it. And that's fine. You see in the rule that there is no violation of the rules if the lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. So you think we should do it this way, he thinks you should do it that way, or she thinks you should do it that way. Some argument, and then the supervisory lawyer says, I'm calling the shots. This could be a reasonable resolution of the scenario and no violation of the rule. But it has to be reasonable. So some of this is going to be certainly fact specific. Now, you look on page 76, you have a chart about reporting professional misconduct. What are your duties under this rule? How does it work? And you have a chart here, and that's good, but you also want to see the form of the rule. So So I want to make a point that I made earlier about this rule as well. What are your duties of this rule, first of all? And so this fits into our discussion of this being a self-regulated profession. But you see that the way the rule is worded, when do you have to report? When is it triggered? It certainly doesn't say that you have to report everything, right? Yes.
When when it raises a substantial question as to that lawyer's honesty or trustworthiness.
Okay. So how do you know that? So we're all lawyers, and we're going to take the analytical approach. I have to know that another lawyer has committed a violation, and not only that, it has to raise a substantial question as to the lawyer's honesty, trustworthiness, or fitness to practice law. And then it's mandatory. So that's interesting. It's mandatory, but you have to make all of these determinations before the rule is triggered. You have to know that something has occurred, and it has to raise a substantial question. And the chart on page 76 sort of points that out. Also, and we haven't done confidences yet, but if we have confidences, we don't divulge those. So confidences are protected under 1.6. And the rule even is worded in that way. Letter C, you say, the rule does not require disclosure of information otherwise protected by 1.6, confidences. Now, I emphasized this before. Look at comment 3 to this rule. So, along with 8.3 giving the lawyer discretion to look at whether or not I know that there's a violation that another attorney is making, that it raises a substantial question about honesty and trustworthiness, then I shall report. Comment 3 sort of puts this rule in perspective. It even says, if a lawyer were obligated to report every violation of the rule, the failure to report any violation would itself be a professional offense. And there's no way that we could keep that up. So the rule limits the reporting obligation to those offenses that a self-regulating profession must vigorously endeavor to prevent. So there is a measure of judgment that has to be exercised in terms of when to report. And so that's why we have this term substantial. That refers to the seriousness of the offense. Seriousness of the offense, and it also goes on to say not the quantum of evidence. So you're not in the position of saying, well, this is beyond a reasonable doubt, this is a preponderance. You make the determination about whether or not this is a substantial question as to honesty, trustworthiness. And then that is what triggers the duty to report. Then there's a discussion about the Himmel case in Illinois. It's just in there, that's on page 78, to make the point that, disclosure was sort of lax, and they used Illinois as an example, but they made an example out of this attorney, and things skyrocketed in Illinois in terms of divulging misconduct. Notice on page 78, Himmel was actually disciplined for failure to report misconduct. Now, his client told him not to report the misconduct of another lawyer who used to be his client's attorney. He was sort of cleaning up the mess of the former attorney, and they were concerned about that impacting the settlement agreement that they agreed upon, and the lawyer never paid up. Himmel goes on to try and get some money, did get some money for the client, but the client requested that he not report this misconduct, and he was disciplined for failure to report that misconduct. He did as his client requested, but he was disciplined. And so that goes to show that although the imposition of sanctions under 8.3 is rare, the book tells us the duty to report misconduct remains mandatory under our state ethics code. So even the states that enforce it, even occasionally, attorneys regularly report misconduct by other lawyers, product of the self-regulatory profession. Exculpatory evidence, problem on page 79. Now, this is a problem where the prosecution has evidence that someone on death row has probably not committed this crime, while the attorney was alive, suppressed evidence that should have been turned over under the statute and under constitutional principles. A case called Brady says that the prosecution must turn over exculpatory materials. Two attorneys are talking, and during a conversation, one of the attorneys is told by his friend that he only has months to live, but also informs him of what he did as a prosecutor. That was suppressing that evidence. The friend says, you should divulge this, waits around, it never occurs. So Harris, who is the attorney, He died without ever revealing that he suppressed exculpatory evidence. That's on page 8. So we are left in the position of having this information. Our attorney friend has passed away. We know that there's some exculpatory evidence out there because we've been reading the newspapers. And now the question is, should we tell? What should we do? What are our obligations under the ethical code? So what do we do? Do we report this misconduct of our friend who's passed away? Yeah. Yes, it's hard.
Given that a man's life is on the line and now, yes, you do.
Mm-hmm. Mm-hmm.
I mean, yes, the attorney in question is dead now, but you have this information, and now that you actually have a name to put with it, you have the potential to save an innocent man's life, sure is. And two, if you don't report it now, and it later comes out that this man is innocent and that the evidence was suppressed, if they find out that you knew this evidence was suppressed, you could be held liable as well.
Yeah. Mm-hmm. And this attorney, so it's been 5 years too since it happened, and then he dies, and then the person tells. And so when this information comes out, they ask the attorney, why didn't you say anything? And he says, I was under great pressure. His friend was dying. He had just had a divorce. He was depressed. He was under medication. His younger son had just undergone open heart surgery. I think the son was 2 years old, but didn't correct the injustice, I'll say, when he knew about it. And this is 5 years later. And so, what do you think happened to this attorney? Any sanctions, or it's a sort of a compelling story on his personal side, but do you think he received any discipline from that? Yeah.
Did the attorney in the actual story, did he know the name of the defendant that was potentially innocent?
Yeah, he knew.
Then there are going to be sanctions because he had it, at least in the hypothetical given here, like, the attorney didn't know until 5 years later who the defendant was that was potentially innocent.
Yeah. But he knew that this information was suppressed, didn't say anything about it in the 5 years, and then it dawned on him that this was exactly the case when it started appearing in the newspaper. Yeah. What do you think happened to him? It's just publicly reprimanded. But there was a dissenting opinion where a judge would have imposed a much harsher sentence. Now, he was charged with violation of 8.3, reporting professional misconduct, and 8.4D, this is misconduct. But notice he's a public official, and 8.4D talks about conduct that is prejudicial to the administration of justice. So there's a constitutional duty to turn over exculpatory materials, Brady materials. So notice this person in our hypothetical, his name is Maurice Lavoie. His name was John Thompson in real life, but this was a death row inmate who was wrongly convicted. This person spent 18 years in prison. 14 of those 18 years was on death row. An execution warrant was served on him at least 7 times, and so there were a number of times where he came within weeks of execution. And so when he gets out, he sues the DA of New Orleans for not training prosecutors to turn over exculpatory evidence. Court awards him $14 million. Prosecution appeals all the way up to the U.S. Supreme Court. In a 5-4 decision by Justice Thomas, the court held that John Thompson was not entitled to redress. A concurring opinion by Justice Scalia says that no amount of training would have prevented the wrongful conviction. So this award was vacated. But this case makes the point that when there is evidence of misconduct, again, this reinforces the duty to report. Look at the chart on page 81. That sort of points out what I just did. And I made the point, look in the chart, about comparable managerial authority and direct supervisory authority. So if the supervisor doesn't know anything about it, then the supervisor isn't liable for that conduct. He has to know about it. But this rule requires that lawyers set up systems to prevent ethical problems. That's what we want to do, prevent ethical problems. That's on page 81 in the chart. So let me set this up. I don't want to rush through this. So when we come back, we're going to start with this last problem in chapter 2. And then we'll just finish up chapter 2 and we'll move right into chapter 3, the duty to protect confidences, where we'll talk about rule 1.6. But the little hearing underscores the responsibilities of supervisory lawyers and your responsibility. This will be your first job scenario. So if you get a good supervisor, that's going to be very helpful. If you get, and this can happen from time to time, sort of lax supervision, you feel like you're swimming, you don't know your way, you have to start asking questions. It's no sin to say, I don't know. Because someone probably has done it before, and at least you can look at a model and gain your way that way. Or you're protecting yourself, because notice the first rule that we have is competence. That's rule 1.1. So everyone isn't immediately competent. That's why it's called the practice of law. You have to gain the experience. And part of gaining that experience is, if you don't know, ask the question. But the little hearing, which starts on page 86, is really a devastating scenario. We're talking about competence. We're talking about the duty to report misconduct. And what does the young attorney do in this situation? This is her first job. This is an actual case that was one of Professor Lerman's students, and we're going to figure out how to resolve this. And you'll see in real life what happened. But the question is, should we report this misconduct? Should we stay on and try and gain expertise in terms of competence? And is the lawyer making the right arguments? Notice what the lawyer says. This is a impoverished clientele. This is high volume. I don't have the time to spend on each and every case to double check everything. They are getting, this group of clients is getting some type of representation. I'm providing a service. Let's just keep going. But another thing to pay attention to in this problem is that the senior lawyer is not taking any real supervisory authority. You see, when they're on the train, he just gives her a treatise, read that, look at the file, match it up. It's a non-adversarial hearing. You'll find your way. And there are thousands of cases coming this associate's way, 1,500 cases. So we're going to analyze, what does 1.1 mean? What does this large-scale practice mean in terms of how we look at the rules? and we'll try to resolve that. And then I'll just summarize the rest of this chapter because we need to move on to chapter 3, and that's the last problem in chapter 2. And then we'll start confidences. The syllabus will be posted by the end of the day, and it pretty much says everything that I've said in class. We'll have a writing assignment, but that'll be later in September. That's on the syllabus. And we generally try to cover 35 to 45 pages of class just because of our abbreviated schedule. But that may be adjusted due to the material. Something may be dense that we have to delve into, and I have to explain more, so that's fine. But it's about 600 pages, and we'll pretty much finish this book, so that's our goal. But this syllabus will be posted by the end of the day today. Have a good weekend.